tenant matters. The start this morning is non-payment of rent. One is Jim Jehosa and the other is Michaela Baker and Gabriel Houghton. You are defendants in a landlord-tenant case. As such, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If you are requesting a jury trial, you have to tell me here today at this first hearing and be prepared to pay the $50 jury demand fee, or file the demand in writing within 5 days using the appropriate court form, Michigan Court Form 22. Pay the $50 fee unless the judge waives that fee. You have a right to have the case heard here in St. Joseph County where the property is located. That's never been an issue. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency. In our county, that's Community Action Agency, a housing assessment and resource agency, that's Neighborhoods, Inc., or a federal help for homeless veterans programs. Unfortunately, none of those agencies have very much money. We sent that information to you with the packet that you got. You do not need a judgment against you to receive help from places listed above. A copy of the summons and complaint for your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation, also known as community dispute resolution. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed, in which case we could have filed what's called a conditional order of dismissal. Our first case is 9 a.m., which is James Jehosa. You said it, Jehosa?
That's correct, Your Honor.
Mr. Thompson is not here. This is his party. He filed the action. He's not here on either of your cases. Mr. Jehosa, have you paid the rent?
I became unemployed and I had they gave me 5 days to vacate. I've had a great relationship with Mr. Thompson, done tons of work for him, and I vacated within 5 days. And the 1 month that I was, because we were on a month-to-month that I was late, I accepted. I told him I would pay him as soon as I got back to work. He said, well, I can't have you there living rent-free. I said, I completely understand. I said, can I get 30 days? He said, no, I need you out in 5. I said, no problem. I've got pictures. The place is absolutely spotless. And I told him he could take the $800 security deposit that I had toward the 1 month rent, which would negate it. And he said there's additional court fees for $176.50. I said, I'll go ahead and I'll pay that when I have it. And he said, tell it to the judge.
He's not even here. He can't give you 5 days to vacate. He has to give you what a rental period is, which would be 30 days. He gave you a 7-day notice to quit, but your rent is month to month. So he needed to give you 30 days and he can't kick you out. I can. Just because he tells you you have to leave, it's not up to him, it's up to me. So you would have been entitled to have a hearing, but you have vacated?
Yes, sir. Yes, Your Honor.
Well, he isn't even here, so you got to tell it to the judge, but he's not here. Doesn't have a lawyer, and it doesn't seem to completely understand the Landlord-Tenant Relationship Act. Defendant has vacated. Plaintiff fails to appear. Well, here he is. Mr. Thompson.
Somebody else right now.
All right, Miss Martin and Mr. Smith just remain quiet. Mr. Thompson, can you hear me?
Yes, sir, I can hear you.
All right, you're 8 minutes late for your hearing. We've been stalling for 8 minutes. And if you can't appear by Zoom, I can have you come in live and in person.
Yes, sir.
Your first client, Mr. Yehosa, says you told him he had 5 days to move. And he couldn't stay there for free. So he says he has vacated.
Yeah, sorry.
That isn't how it works.
I
He
apologize.
had a 30-day month-to-month tenancy. You were required to give him 30 days notice. You gave him a 7-day notice to quit. So you're representing yourself, but you don't really understand the law very well. And then you show up late, which does not make me very happy. Anyway, he is vacated. He's no longer there. You did file a supplemental complaint for money damages. As he indicated, he was going to allow you to take the security deposit for back rent. Mr. Gehosa, he did pay the fee for supplemental money damages. So after you vacate, you need to turn in your keys and give your forwarding address in writing within 4 days of moving. Have you done that?
Yes, Your Honor. I did that via text to Ben, gave him my address. He asked me for that.
All right. Well, you vacated. There may be a subsequent hearing regarding money damages, but the possession case is dismissed. Defendant has vacated. Do you agree with that, Mr. Thompson?
Yeah, yes, sir.
All right. Once you take possession of the premises, you can determine what you're going to do. And if you wish to file a claim for money damages, you can do that.
The claim, sir, for the money damages, the claim should already be included with that filing as well. There's a couple things. And one, I do apologize. I had some computer issues on a VPN this morning. So it took a second to figure out. But so my apologies on that. So, but the second piece of that is that the filing, the judgment for Monies should be filed already and included with that paperwork.
It's not. You could really use a lawyer to help you with this. You didn't file the right side of thing. You filed a detail of expenditures and a couple pictures of some stuff, but that doesn't amount to a claim for supplemental damages. You've got to list what it is, how much is rent, how much is utilities, how much is court costs. So just adding some paperwork. If you're in the landlord association, which you certainly should be, Ms. Richmond can help you with that. She does a good job with her supplemental damage complaints. So,
Miss Richmond, sir, Miss Richmond did assist me with this. So I'm not sure what paperwork, if there's paperwork missing there. We walked through the entire packet. She's got a packet.
Yeah, there is no complaint for supplemental damages. You said you paid the fee for it. You filed a demand for non-payment of rent. You filed a 7-day notice to quit on a 30-day tenancy.
Come on. No, come on.
I don't want to listen to that. So anyway, you could file a supplemental complaint for money damages.
In there.
And
come on.
Ms. Smith, I'm going to put you and your dog in the waiting room until we deal with your case. At any rate, he's moved, so the possession case can be dismissed. Mr. Joseph, we aren't done. There's a money damage case, we still need to do. When you his, forwarding address.
We did a validation on the postal records, Your Honor, and that address is not registered to his name.
It doesn't have to be registered to his name. Do you get mail there, Mr. Joseph?
Yes, Your Honor.
All right. This matter is dismissed. We'll address it further when it comes to the issue of money damages.
Thank you,
All
sir.
right, you're free to go. All right, next.